Well, thank you, Chair Mark, and thank you, Registrar board members as well. Yes, the visit yesterday was well received by staff, and they really appreciated it. Recognizing their hard work in developing the system. The system was implemented back in May of 2023 as a pilot program to see the board with staff to use something that was a little bit better than our current information system. That's something that's not statewide currently, but the reason it lends itself very well to our unit was because we have about and interact with the public and contractors on a very regular basis, especially imposing enforcement measures we just bring action against their licenses. The reason for that transition was necessitated by a lot of hard work that staff needed to decide because of their current workflow. One best feature for that is security, which is a huge priority for our enforcement division. Staff having the same sign-on through their authentication for Microsoft and our team login to go ahead and do that. This enables them to work remotely during the pandemic and afterwards, work funded in a more efficient way. So happy to report that it automated a lot of their workflows, eliminated a huge amount of redundancies, had a huge impact on reducing costs as well, moving from paper-based systems to digital. Obviously cut down and reduce our need for paper, office equipment, supplies, things of that nature. So it's something that we look forward to rolling out to the rest of the enforcement staff. It's going to be a huge impact. It's going to have a huge impact on the enforcement capabilities moving forward, and it's going to finally bring us into a more modernized enforcement. Any questions?
Questions from the board? Great.
So I guess first off, I want to echo the appreciation for the work that this group did on automating this process, and kind of add to your point on the benefits, which is that this is one of the things the public can see all the time about us. I think some of the outstanding work that we all had the chance to see yesterday with the fires is kind of like a submarine below the surface, where it's all going on and it really makes a difference to the folks that are fire victims, but the whole universe can't see what an amazing job the CSLB is doing, which is terrific. But we can see sort of the internet piece, and having to mail pieces of paper in is really a 21st century activity. So in addition to the benefits that you listed, I appreciate that the staff is also helping the CSLB kind of represent in a modern and efficient fashion to the public. And I think for contractors to keep feeling more relevant is important. So it's another benefit of the work that your team did, and I really appreciate it. Thank you.
Thank you. Thank you. Any other board member comment? Thank you. And again, Steve Grove and his team, and Jesse and Jerry, appreciate all your hard work. And you know, obviously mine was a big part of that too. So thank you. And Renee, we have a comment.
Yeah, sorry, I just, RIP Chief weighed in. I mentioned that the online app for the sole owner will be live in April. I was optimistic. So I'm going to retract that statement, and I will get back to you on the live date.
Okay.
So my apologies.
Thank you for the correction. Okay, thank you. Thank you. We will move on. So legislation. Leading us through the legislation portion of our meetings will be Board Vice Chair Miguel Galarza. Miguel, the floor is yours.
Thank you, Chair. My name is Miguel Galarza, the Vice Chair, filling in for our Legislative Committee Chair, Bill Martin. We wish him a speedy recovery. Jen was wrong, times is related. Let's begin with this legislative agenda. Item 1, Rebecca, please provide us an update.
Thank you. So agenda item 1 is an update and discussion regarding the board's legislative strategic plan objectives. I'd like to highlight the progress that the board is making on goal 3.1, which is to improve communication with legislators to convey CSLB's vision and stress the importance of bicycle. On January 29th, Chair Michael Mark, Legislative Committee Chair Joel Martin, Registrar Pope, and I visited legislators to discuss CSLB's legislative priorities and its disaster response efforts. We met with Assemblymember Berman, Senator Small Cuevas, Senator Valladares, Senator Grayson, Senator Neal, and staff of the offices of Senator Arreguín, Senator Menjivar, Senator Ashby, and Senate Business Professions and Economic Development. The visits helped us secure offers for our sponsored bills and maintain connections between CSLB and legislators. Developing these relationships helps us to disseminate our consumer protection message not only to the legislative decision makers, but to the constituents that they serve. I followed up each meeting by connecting legislative staff with our public affairs chief, Catherine White, so that she and public affairs staff could provide more detailed information to those offices regarding CSLB's outreach efforts, including senior scam, stopper events, and information on safe hiring practice. I'm hopeful to schedule another legislative date soon, as there's still lots of members to connect with. And in the meantime, I've been steadily making the rounds to legislative staff.
Are there any board members, comments or questions on this item?
I will just like to say thank you, Rebecca May, for putting together the alleged visits. It was very helpful. I think the perspective of myself and alleged chair Joelle Barton attended those meetings. We as CSLB is highly recognized as consumer protection, and that was just our mission. So everyone did understand that when we met. They were trying to do everything they can to help us as a board continue that mission for California. So thank you.
Any other comments from board members? Seeing none, does the public have any comments? Seeing none, we'll go ahead and move on to the next agenda item.
This item is regarding a non-substantive update to contractor state license law. There's no action required. In December, the board approved 4 non-substantive amendments to contractor law for inclusion in the Senate Business Professions and Economic Development Committee's omnibus bill. After the board meeting had taken place, staff determined another amendment related to the industry expert reimbursement costs for investigating a workmanship complaint was needed. The board was not scheduled to meet again until after the proposal was due to the legislature on January 15th. So staff conferred with legislative chair Joelle Barton on how to proceed. Pursuant to his authority in the board member procedure manual, as legislative chair, Joelle Barton authorized staff to include the new amendment in its submission to the committee to inform the board as soon as possible. And that's what I'm doing today. Specifically, the new amendment removes the requirement for CSLB to add industry expert reimbursement costs to licensure renewal. In practice, it's preferable that the licensee be advised of the reimbursement or the requirement to pay for the reimbursement for the industry expert costs when the letter of admonishment or citation expires. It's still necessary for these costs to be paid before the license. Further, adding the fee to the renewal would take additional IT programming and staff resources to change internal renew processes and might result in support. Again, there's no board action.
Any board comments on this item? Seeing none, any public comments on this item? Okay. Since I see none, let's move on to the next agenda item, which will be agenda item 3A, which is related to the board sponsored legislation. We're going to sponsor 4 bills at the December board meeting, and there are no action required on the bills today. Now this can be found on the material starting on page 76, but I have a reminder that these 4 bills are as follows. They are to clarify CSLB is not responsible for legal bills or fees on civil claims against cash deposits filed with CSLB, including accessory dwellings or ADUs as defined as the definition for home improvements and increased penalties for violations of progress payment rules, authorizing a narrow exemption for requirements that all licensees must carry over the stock insurance even if they do not employ any workers, and increased minimum civil penalties on those citations. Thank you, Senator Grayson, Rivera, and Assemblyman Berman and Carrillo for authorizing these bills on behalf of CSLB. We, board members, have any questions or comments regarding the board responsible bills? Yes, ma'am.
I have a question. So, real time, I know legislation moves quick. Which of these are kind of closest to any hearings?
I think committee hearings are probably starting in most people,
Okay.
so I anticipate fall.
And so at our June board meeting, we should have an update, and soon we're probably gonna have a legislative committee meeting somewhere between now and June, so that'll be another chance for update. Okay, thank you.
Any additional board member comments? Any public comments? Seeing none, I'm going to move on to agenda B, 3D. These are other bills related to CSLB and the contracting profession. After board members discuss and public comments on each of these, we will vote on the board position. Item 3D1, Assembly Bill 476, Gonzalez. Analysis of this bill can be found on page 87 of the material. This bill requires CSLB to establish a new licensure program for scrap metal copper sellers. The bill provides that existing licensees are not required to be licensed as a copper seller who sells scrap metal copper. Staff recommendations and opposed. Position on this bill. CSLB recognizes the financial harm that licensed contractors incur by copper theft. However, establishing a new license type will require CSLB to extend a significant amount of resources upfront, including extensive IT updates and test development. It is unclear the potential license pool for copper sellers was substantially a license program. It is also unclear whether licensed copper sellers would have any discernible impact on metal theft. While the staff is recommending the vote, staff will continue to discuss this bill with the author and the responses of the system amendments to alleviate the board's concerns. Are there any board comments or questions on this specific bill? Again, bill 7436.
I guess I just have a question on this one. So the whole goal on this particular bill is make sure I'm hearing you correctly, like a requirement for like copper scrap sellers when they go into construction projects that they would have a required license. Is that kind of where we're at, or?
They have to have a license to sell copper. Contractors would be exempt, so contractors that already sell copper don't have to have a license. I mean, they have to have this additional license.
Yeah, remove it, Rebecca. We're saying our licensees would be exempt, but if you're someone that's not licensed now and you're gonna try to sell copper at a recycler, you would have to be licensed to do that.
Yes, it would create a whole new licensing.
Through our board?
Through our board.
So, our minimum, so right now, as of January 1st, we're at $1,000. So is it like any copper that is being turned in would require a license then?
Yes, I think there's some exemptions in the bill.
You got any communication from the author regarding this?
We have some discussions.
And to make sure I'm hearing, so the staff recommendation is to oppose the position. In my opinion, yeah, like I'm just trying to think the resellers. This is obviously like underground economy stuff that we're talking about here, right? Copper, people just breaking into buildings potentially, taking copper out and then trying to take it to the resellers. So what I heard is we would have to have a contractor's license to resell to the individual resellers, which might not be the worst thing, right? To be honest with you. So there's a question.
Yeah, I don't think it's not a contractor license. This is,
It's a commercial
this is
license.
nothing to do with contractor license. It's a new licensing program in CSLB for the sale of copper.
Yeah, I think it is a seller's license, not a construction license. It's not your fault. I think it's the way the bill is written.
Yeah.
It sort of morphs from resellers of junk, non-ferrous metals will need a license. And oh, by the way, CSLB licenses, so people can deal with metals, so it doesn't really say what's going to happen. It says, I believe it mentions some counties that currently have programs in place to deal with this type of economy. But I think the opposition is, we don't have a test for it. We'd have to create one. We don't have enforcement for it. We already have plenty of enforcement, and they're at the county level able to do this. It's not my bailiwick, but why not license the purchasers and make them report, like, you know, when, so like a bank gets something over $10,000, they have to report it. If you're buying metal in the underground market, maybe you should have to report to someone. And I doubt I'm telling you what to do policy-wise, but I don't think that's something that CSLB's board should just jump right into.
That's all well said. I guess as, we've been the victims of copycat, I'm sure this is a big problem, but I don't see how it's the CSLB's purview. So I think it's a very important problem that is actually going to be able to find it.
I agree. That copper theft is the issue, that's not contractors' problem.
How does this impact the consumer? I mean, you go in and sell copper, I mean, it's a requirement.
You have to show, some cities and counties, you have to show a driver's license.
Right.
Or, you know, license.
Right, but that license.
I fully support regulating, trying to get rid of stuff, it is a big issue, but it's not a contractor.
Yeah, I think, from my perspective on, obviously, maybe the term reseller is not, it's, if I'm pulling out, 1,000 feet of them, CM 500, I'm not trying to resell it to resell, I'm trying to scrap. And getting scrap and accountability, guys buying this stuff, individual, the organic a criminal doesn't care what it's licensed. It's stealing stuff.
So, I will make the motion of the recommendation of staff to oppose this bill and then give you the opportunity to bring something back to us if there is. That's my motion.
Any other board comments? Any public comments? Mark, Michael, you made the motion. Is there a second?
Thomas Ruiz.
Robert, will you so kind as take a roll?
Michael Barr,
Aye.
Joel Barr has an excused absence, Martin Cobos. Aye. Miguel Guerrero.
Aye.
Amanda Guile. Alan Guy.
Aye.
Jacob Lopez.
Aye.
Diana Love. Henry Nutt.
Aye.
Steve Pinelli has an excused absence, Joseph Preciado.
Aye.
Jim Roy has an excused absence, Thomas Ruiz.
Aye.
Mary Tucker.
Aye.
Motion passes.
Thank you, Robert. Moving on to the next item, item 3B2, Assembly Bill 1327, the analysis is bill can be found on page 89. This bill will require all new contracts to include the contractor's email or allow the consumer to cancel the home improvement contract via email and act recommendation is neutral on this provision on this bill. By including additional ways to cancel a home improvement contract is good for consumers. Canceling by phone does not provide a record of the cancellation, so the consumer will disadvantage. contractors that I haven't received all. Any board members have, comments on the specific bill waiting from the same?
I have a comment. Can the bill be amended?
That,
Can the bill be amended?
right now, we've taken a neutral position, right? I think it can be amended.
I would make a suggestion, if we get to that amendment part, that a phone call could be made with the follow-up response of an email that they received a phone call.
Is a suggestion to remove the telephone call part of the bill and leave it at email?
No, keep the telephone part in, because there's a lot of seniors who don't do a lot of the social technology. So they would be more comfortable with picking up the phone and then perhaps getting a response back on their email or phone or something, or, you know, family member can help them with that.
If I could, I think that's what's important, though. There's something in writing, because the consumer is at such a disadvantage when they later try to state they canceled by a phone call and there's no record of it. If they wind up in court with the contractor suing them with their small claims in Superior Court, they're not going to have a defense. That's why we're concerned about it. But your idea is a good one, as long as it's responded to and say, yes, it's a confirm your phone call, or you cancel the contract, that would be okay.
Or they can send them a letter in the mail, as a follow-up letter.
But if they don't get that, we just wouldn't want to encourage people to cancel the contract by phone without putting it in writing. Because the contractor may well deny having received that call.
Can we add language about that if it's a phone call, that there's X amount of days that there needs to be the follow-up so that it's clear on both sides? And give me a phone call.
It's good to me.
So this is what I heard is like, you're looking, Diana, for a pose unless amended position by our board. Is that what you're seeking?
Yes.
We currently, so the motion would be, someone needs the motion after public comment. Public comment? Anyone? Hearing and seeing none. Is there a motion?
I'm gonna ask that the attorney here help me with that language that I just.
I believe the motion tendered is to oppose unless amended, to eliminate the simple telephone call, and unless it's also paired with a follow-up email, either by licensee or by
Email or letter.
or letter, by writing.
In writing.
It's already said, current code's already a letter, right? So we just all we want to do is add email.
Right.
You can call and email, but we're just adding email. It's a line contract.
So the motion would be to allow an email or telephone call,
Just an email.
I think
as
that,
long as it's accompanied by a writing.
I think the difficulty is the summary says email or telephone call, and we just need to make, the question at hand was to add make sure email plus a written notice. And if there is a telephone call, then there is a proper written notice. That's what's not in this.
Yes, written notice, like that.
It's depending on if you just took, I think what Alan was saying is if you took out telephone, because frankly, once you send it also that email, we're now sending it. Take out the telephones. You can call all you want, no one's talking on the phone. But you have to. So we're kind of proposing, if a friendly amendment to your thought, Diana, would be something like, what if we propose unless we delete telephone as one of the ways you can cancel a contract?
No, my proposal is to keep telephone. I want seniors to be able to call and just have a written notice that their phone call was received. In some form of action. Yes, some kind of written response.
So the motion to oppose unless amended to add to the telephone call notice that the contractor be obligated to confirm in writing the telephone call within a certain period of time.
So I guess I'm not clear
Yes.
how that would work. So if a contractor doesn't confirm it in writing, then is it canceled or not? Because I think that's the same as a good. Hopefully a reputable contractor could call and say, I want to cancel the contract, or figure out how to cancel the contract. So I think the protection piece is people that are trying to be sketchy, in which case require the contractor to confirm it. If they don't confirm it, then it's not canceled as far as I can do.
The most fraud, this life classification has the most fraud. We have a special fund set up to help with this, so let's not bring ambiguity. He says she's doing the phone. You can call and cancel it. If you want to cancel the contract, then you should just add, you know. This phone call's gonna make it worse. Phone's gonna. That's it.
Because people would still be welcome to call their contractor all they want. We're just saying that's not a way to cancel a contract. So now have to have, you know, one piece of writing to cancel your contract, but email, yeah. It was not making it easier.
So there's a motion on the floor. Is there a second?
Mr. Bowman. John, this.
Yeah.
I don't know if the motion is still on the floor. Are you withdrawing the motion as to the telephone call, and we oppose it as written unless the telephone call is removed.
I'm
A
not,
telephone call without any writing is removed.
I'm not
Because I think the
withdrawing.
problem.
We voted down, but I'm not withdrawing. I want the telephone to remain in there.
I'm proposing an amendment. I don't know where that is as far as do I do that after the second one.
I think we'll need to, because the amendment has not been accepted, we'll need to take a vote if there's a second on the motion after this. But I believe your motion, Member Love, is to support. Change the neutral to support email or telephone calls.
And just add in the written.
You restate.
That's not what I heard.
The requirement now is a writing within a certain period of time. So this bill, I believe, correct me if I'm wrong, is to allow, in addition to the writing that's currently in place, an email or a telephone call to cancel a contract.
Is it either or?
It is. Well, I'm reading the word "or" in
I think Diana wants to accept the phone call as long as the contractor confirms receipt of it in writing. But if they don't do that, then you would need to send an email at the very least. So,
Yes.
okay. So the motion is to,
Okay, so the phone, someone makes the phone call and no one answers the phone. But it can happen all the time. But this is a recourse.
they need to send an email or a letter if they don't get a written response to the phone call. Check themselves. It's not on the
Someone that says.
that's a different statute, so, right, that's a different bill.
So the bill says, a notice of cancellation made pursuant to the 3-day right to counsel, 5-day right to counsel, and 7-day right to counsel, provided in section 7159 made to the seller orally by telephone in lieu of written notice.
And I think the members that have expressed a concern is, you've got a bad contractor out there that's gonna get a message on his machine or no message at all, or take a phone call, be real polite about it, and deny it ever happened.
Yeah, that's the issue.
You then are left with a bill that just, you're sending the same two people into a forum to determine something where it's he said, she said.
Unless they get something back. No.
Right.
Not sure what the motion is.
Diana, can I try sort of recapping what I think?
Okay.
Is that if we were to say, would allow for cancellation via email in lieu of a written notice, something like that. So that would be really super clear that you either have to mail something or there has to be an email exchange. That's it. So it doesn't preclude anyone from calling anybody, but it's saying there has to be something written down for it to be canceled, because otherwise, you know, to John's point, the consumer's not protected because nothing's written down by anybody. So we just want to
Since I
clarify.
love editing, I think you have the exact point, which is the bill as written would be a cancellation by email, which adds, so it'd say the written notice provided by this statute may be by email or a telephone call and an additional confirming writing.
So I think
Is that-
that
But you're concerned?
well, part of the issue is like you're relying on the contractor. If you call them, then they need to send you back a writing and notice which if the consumer does not receive said writing, that's what's difficult. Or they could say, they've never received telephone calls. So that way, there just needs to be, protect the consumer, something in writing sent to them.
So
the,
it wouldn't have to be from the contractor, it could be from the consumer. But making the call within the 3 days, you get a cancellation if you send an email on the 4th day, or write a letter saying, this confirms our telephone call where I canceled.
We also want to leave the power in the consumer's hands. If we shift this to the contractor's power to say or not say that they got the phone call, we're kind of taking away the consumer protection, which is the consumer's the one that should have the right to send something that says it's canceled, whether it's by email or by mail or however they send it. It's up to them.
Phone call represents false sense of protection.
yes.
Right, so you think that's something that you actually haven't. But there's a he say she say back beginning, so I think that language does represent a false sense of protection, especially when it's a service contract. Exactly, that's what we're all. Yes. Yeah.
They take that up.
You can even require a contractor to write you back within 3 days and set you up for false hope that you cancel your contract. And then what's the recourse after that? You'll get that response in 3 days.
I mean, there's also times when you send something to people, in this case contractors, who say they never received the email. But I know you have what you sent on your end, but that doesn't mean that they received it on theirs. So there's ups and downs.
But at least at that point, there's something in writing for you as a consumer versus you picking up the phone and leaving a voice message or something. So so there was no second from Ms. Love's motion. There was a potential new motion that's on the table, or Ms. Love, you could try your motion again. That's where we're at right now.
We're at it. That's a new motion. So is there a new motion?
Would you like to make a new one for that, or if not, I would like to repeat.
No, because I want the telephone today, so I'll let you know.
All right, I'd like to make a motion that we delete more telephone out of this. Or I'd set, I guess, a closing alternative.
Robin? Roll call.
Did you say leave the telephone call?
No, delete more telephone.
Yeah.
Just take telephone out of this, but leave the rest of what they're proposing to change, projected as out of email.
Thank you.
So we're proposing AB 1327 unless amended to remove the phone call and email.
Just to remove phone call. I think they already have email in there. So I think the only amendment, if I were looking at the summary, right, see how it says by the homeowner, by email,
Right.
cross out more telephone. That's
Okay.
it. That's the only change that I would suggest. And if they accept that, then we would support it.
Right. Thank you. Who's the first one? I'm sorry.
Gary, I can read how much sound guy. Second.
Yeah, thank you. You ready?
Maybe board
You don't
comment.
need to say the word in public.
Public comment on those, who made the motion? All on the second motion. All members? Okay. With that, Robin, please. Michael Mark?
Aye.
Joe Mark has an excuse the absence of Wendy Cookbooks.
Aye.
Miguel Galarza. Aye. Amanda Gallo.
Aye.
Alan Guy.
Aye.
Jacob Lopez.
Aye.
Brandon Love.
No,
Henry Nutt.
Aye.
Stephen Elliott has an excuse of absence. Joseph Pizziato.
Aye.
Kim Wayne has an excuse of absence. Thomas Reed.
Aye.
Harry Tucker.
Aye.
Motion passes. All right. Moving on to item B3. Assembly Bill 1002 by Gabriel. This bill states legislature's intention to strengthen and remediate against licensed contractors who repeatedly commit legal violations against workers. This is a non-substantive. This bill is considered a spot bill and intended as a placeholder for future amendments. Accordingly, there is no action required on this item. Staff will continue to monitor this bill for amendments to bring it forward and weekly meeting agenda. Are there any board member comments or questions on this item? Seeing none, Any public comments?
Yeah.
Oh, Madam,
To be on an idea of what that discipline is.
So right now, it's just voluntary. And it's more moving than something. So you will. We're working on it. Can you speak up a little bit? Yeah, sorry. So there's, as of this morning, there's nothing other than legislative bills and legislature. Nothing substantive in it. So as of this morning, there's still nothing substantive in it. But I do anticipate that they'll amend it at some point soon. And then we can move it.
Rebecca, you're proposing a potential ledge committee meeting on April the 11th. So hopefully we have information then.
I think that the spot bill deadline to put in the amendment is March 18th. So it can't go on forever, just in the spot.
And I think obviously, the underground economy is very important to this board, and if a contract is failure to pay wages, we would hope the bill offer would have as much discipline as possible for these bad actor contractors. So, they said if you're having any communication, at least that's been the stance of this board for long time history. So,
Seeing the importance of the issue, we wanted to make sure to include the spot bill in the agenda, in the amendment, and the amendment.
Sure. Thank you.
and to your point, Chair, which is aligned very closely to our focus agenda. Then, any other board comments? Any public comments? With that, we'll move on to the next agenda item, which is item 3B4, Senate Bill 641 by Ashby. This analysis bill can be found on page 92. This bill will authorize the program of the Department of Commerce to do repairs, including CSLB, waive certain license and renewal requirements during a declared federal, state, or local emergency, such as examination of facility, ambulances, and or maintenance. Specific to CSLB, the bill provides that only A engineering contractors, B general building contractors, and C 61 limited specialty classification can engage in debris removal. This bill will allow the Registrar to determine if additional classifications are authorized to provide removal during the state of emergency on a case-by-case basis that require additional hazardous substance verifications if applicable. We declare this bill does not force CSLB to waive any licensing requirements or require licensees to perform any work do not have expertise and or to do so. It also allows the registry to make these determinations if appropriate during the duration of emergency. Currently, the staff recommendation is to support this bill. The bill will also allow CSLB to meet specific needs of each disaster more efficiently and effectively and to best serve the public and its applicants and licensees. This bill contains an urgent clause, meaning it will come into effect upon the governor's signature. Staff has suggested amending the author's statute to include clarification that the classification permit to perform the briefing also allow the registrar to require as well training. Yes.
If I could just comment on that. We're working very closely with the LA County Wildfire Task Force, and what we're planning to do with DCA approval early next week is put out a bulletin that's going to be very clear as to the classifications that can do the debris removal in this declared disaster area in Los Angeles County. And one concern with the bill is that it says C61, that we don't authorize C61 to do debris removal with this wildfire. So the classifications that LA County is going to issue permits for are the A, general engineering, the B, general building, or a combination of the C12 grading and C21 demolition. So that's what they believe is most important, those classifications to protect the public with the debris removal. They're not, as of the last time I spoke with them, and Mike were part of that call, they were not willing to issue permits for any other classification. They're also requiring the hazardous material certification that CSLB tests for and provides that certification on the license record for our public license lookup. And the reason for that is they believe that contractors are more likely to understand the HAZWOPER requirements. So LA County, and this is what staff support, is emphasizing that if you're performing debris removal in this debris removal cleanup here in LA County, that your workers have the 40-hour HAZWOPER training. So that's a requirement. And I don't know, hopefully our concern is would this bill in any way require something different than that? Because we want to be in sync with the LA County Wildfire Task Force and their permitting staff.
I don't think that's what I've already provided you.
Okay, very good.
We're not, it's not, you don't have to have HAZ certified on your license. The workers have to have the HAZWOPER.
Well, LA County is requiring that you have that certification on your license. And they've asked us to come up with a list of contractors that have the classification I previously mentioned with the hazardous material certification. And I think we came up with a list of 1,700. And what we're proposing, or in the process of doing, Catherine could provide more information on this, we're sending out a notice to those 1,700 to see if they are open to receiving bids. And this is for those that opt out of the state-run program. So as of earlier this week, there was about 877 that opted out. But the idea is that we'll identify contractors that will be qualified to give bids to property owners, and that list will ideally be on the county's website.
This doesn't mention the HAZ.
I had that conversation. I think it's part of these commitments. Over that.
It's just.
Well, there's two different, there's a HAZ certified license and there's training for your employees. There's HAZ certified and HAZWOPER. It sounds like LA County is requiring both, which is what the state of California is.
Yes, they want.
That's not clear to you. Okay.
So the bill currently has the certification.
Okay.
One more suggested amendment.
Okay. Great.
And again, it would be at the discretion of all of them.
Thank you. Are there any comments from board members?
I have a question.
Yes, ma'am.
So the CSLB administration, are we signed off?
Well, for this debris cleanup in LA County, it's going to require that you obtain a permit from LA County. And so they made clear as to who they're issuing permits for. We're just almost in daily communication with them. It wouldn't be us signing off for it. We would be putting on the license record though if somebody has a certification. But it's LA County that's going to be the gatekeeper, if you will, to require the right classification, the right certification, and the HAZWOPER training before they're going to issue a permit for the debris removal because of the environmental impact that it has if we don't do it appropriately.
But CSLB does not provide HAZWOPER training.
No, we do not. That's federal EPA.
This legislation mentions that it's a 40-hour HAZWOPER training. Is there two? There's a 40 in the name.
And 20.
Yeah, 40.
It's actually
40 is the baseline. They were done the training, got in 40. To an 8 when you're doing the training, and it's great when motion of fine. Right. But you can make should be a 40 hour for those of them.
For the worker or for the contractor? It's for the worker.
Is that for the determining the jurisdiction, including current jurisdiction of the changes?
Well, here's Steve has been asking me about this. So we're getting a lot of calls that there's workers and out there without the protective equipment, and arguably they haven't had the house water training. So the question would be, how is that going to be enforced? Mike researched it. He's the CSLB researcher, and he found the labor code, and we have, in a way, jurisdiction over that. But right now, what we're hoping to do is make interagency referrals to the Division of Occupational Safety and Health. And hopefully, Steve's going to be able to leverage his resources with the Labor Enforcement Task Force for them to have a more active role. But that would be something that we might want to discuss at our enforcement committee meeting. It comes down to the use of resources here. We're out in the field, we're looking at the license requirement, the workers' comp requirement. Do we want to look at whether they have the house walker training? We're hoping that DOSH, DOSH, that they'll do that for us. But right now, the staff are telling me, at least, Steve, or I think you're telling me actually, that they're not as active out there as we would like them to be. Do you want to comment on this?
We're planning to get a joint operation in early April. Yeah. Sit around now.
As far as language goes, what would you think about something like has water training for EPA requirements? And that we don't have to spell out what they have currently, and also if they change or increase something like that.
Any other comments from board members? Comments from the public? Seeing and hearing none. Is there a motion?
This report is amended.
As amended.
Just recommends. Because this bill has a emergency clause, it might be to the governor's office for signature.
Does that mean it'll say C-61 instead of 12 or 21?
I have provided these, I've already provided these to.
So they're all-
So they're, and my, I stated, so. Bill.
If we support it, they can subsequently amend it, that's fine. I can support it.
Second.
Second.
Statement is from Henry. Robin. Michael Mark.
Aye.
Joe Ward has an excuse to absence by the provost. Joe Galarza. Aye. Amanda Guy. One guy.
Aye.
Jacob Lopez. Aye. Diana Love.
Aye.
Henry Nutt.
Aye.
Steve Pinelli has an excuse to absence. Joseph Preciado.
Aye.
Jim Rowan has an excuse to absence. Thomas Ruiz. Mary Cyphers.
Aye.
Motion passes. Thank you, Robert. Next item is item 3B5, Senate Bill 784, Roswell. The analysis of this bill can be found on page 94. This bill increases the 3 and 5 day cancellation period for home improvement contracts to 5 and 7 days. This bill prohibits lenders from requiring loan repayments until they confirm the construction work has been completed and operational. CSLB clean volume for home improvement projects, particularly solar, have been significantly in recent years. These complaints for lands and home improvement projects are incomplete, despite the contractors having received payment from the vendor for work not performed and loan payment being due. While CSLB does not oversee lenders and cannot enforce provisions related to lender enhanced consumer protection from unscrupulous actors in the home improvement industry is the priority of CSLB. Accordingly, staff recommends a support position on this bill, and staff will work with the office to strengthen consumer protection in this bill. Given that, any comments from the board on 784 Roswell? Yes, Ms. Love.
I support the recommendation. I just want to ask, is there an age attached to senior citizens? What is it? 50, 65, 62? What determines a senior citizen?
Well, I think in the penal code, I think it's 65, I don't know. 65 is generally what we.
Thank you. Okay.
But
Any other comments?
I guess my question, I think they're changing the existing law, which includes senior citizen language to, for everybody. Blanket statement, right, of the 5 to 7 days, Rebecca, is that what it is? So the senior citizen portion is going away and the bill's gonna be increased for 5 to 7 for everybody.
I'm for everybody to send
Okay,
So we still have now 7%.
yeah, it's increased, whatever it is currently, it's going to be increased from 5 to 7.
Okay. Still want another age.
The age may be 62 or 65, but.
Yeah, I mean, because if we go by AARP, it's 50
That's right.
as a senior. That's why I'm asking.
For the movie theater, 55?
Yeah.
Yeah, the bus is pretty dubious. I know. Trust me, oh boy.
So for clarification, is there a motion or, is there good more?
I've got a question, just for clarification here. In the summary of this bill, it talks about how that the systems are given, that they get final approval by all permitting agencies and are operational. I don't want to split hairs here, but operational versus operating, because we talked a little bit about, or actually later in this packet, we talked about there's an instance, page 103, of a consumer whose system was installed, but it wasn't connected to the grid. So it could very well be that the system is operational, but not yet operating because it's not connected. So I'm just wondering, my question is about, is in terms of what do you define as operational in this instance?
Can I comment on that? That's been something we've been going back and forth with the solar industry on, that for our purposes here, we protect consumers, and operational means it's connected to the grid and they're enjoying, they're receiving some benefit from it. So that's the way we look at it in enforcement.
Thank you.
And then any comments from board members? Any comments from the public? With that, we move back to the motion. Is there a motion?
Motion to approve. That recommendation support this bill.
No amendments.
There is no amendments needed.
Very good. Michael has a motion, is there a second? Okay. So nothing. Robin, who was the second? I'm sorry. Oh. Thank you. You ready? Michael Mark.
Aye.
Joe Barnett, excuse the absence, but you go votes. Joe Garza. Aye. Amanda Gunnell.
Aye.
Alan Guy.
Aye.
Jacob Lopez.
Aye.
Diana Love.
Aye.
Henry Nat.
Aye.
Steve Billy has an excused absence. Joseph Feliciano.
Aye.
Jim Lane has an excused absence. Thomas Ruiz.
Aye.
Mary Tyker.
Aye.
Motion passes. Thank you, Robin. And in my pleasure to fill in control, I always enjoy the legislation.
Thank you. Thank you. With that, before we move to enforcement committee, we're going to take a quick 10-minute break. We'll be back at 11:03.
You'll do a good job.